whatever I've gathered from the summary, what I've seen, based on that, my comment is that number one, its timing is rather unfortunate. A day after the dissolution of the National Assembly was not probably the right time. It should have been done a week before, so that if the National Assembly considered it appropriate to amend the law and then re-promulgate it, it would have been able to do that. But since the judgment has been delivered a day after, so National Assembly is not around to take any action. So National Assembly in a way has been prevented from taking any position in the law or even initiating a new law. So that's unfortunate. Second is that this is about Article 184, sub-Article 3 of the Constitution. And this article gives extra powers to the Supreme Court to take suo motu action when some fundamental rights or civil liberties are threatened. But Supreme Court after Supreme Court had been rather abusing this provision of Constitution, and they had been taking suo motu action on almost everything. So there has been a lot of resentment among the legal community, and they thought that suo motu action on almost every law and then no provision of an appeal is contrary to the basic principles of justice. So therefore, some kind of a provision of appeal should be there. But sadly, that could only be done if the Constitution was to be amended. But since we did not have the required number of members in the National Assembly, so Constitution could not be amended. So the National Assembly went along and they created a new law which expanded the scope of the review of this law, of the decisions handed by the Supreme Court under this law. So expanding the review scope was not really an appeal, but it was something next best thing to an appeal. So I do not think that it was contrary to Constitution or it was something which was exceeding the powers of the National Assembly. I think it was the right thing to do, and it should not have been struck down. And number three, if at all it was to be struck down, it should have been a full court should have been convened, or a larger bench should have been convened. It is the same three-member bench which had been delivering most of the decisions in the Supreme Court under the leadership of Mr. Umar Ata Bandial. So I think a larger bench, or preferably a full court, should have been convened to make a judgment on this. And also, the date is very interesting because Mr. Umar Ata Bandial will be retiring something like 16th of September. So now, even if this review has to be filed against this particular judgment of the Supreme Court, it has to be filed before 11th, because today is 11th, so only 30 days time limit is given to file review. So if a review is filed before 11th, that will again give the opportunity to the present Chief Justice to dispose of that challenge, and it may not be reviewed by the next incoming Chief Justice. So this choice of the date and the timing is very interesting. This will have an impact because according to this law, which has now been declared unlawful, but the law which was passed, that could have provided an opportunity to Mr. Nawaz Sharif to file a review against his disqualification for life and against his disqualification to hold the party presidentship. So I think it would affect his ability to take part in the elections and in the election campaign, not necessarily about his coming back to Pakistan.